You do not have to speak. Thank you. So I think people are slowly joining. We can now start the session. First of all, good morning, good afternoon, good evening, depending on where you are joining us from. And welcome to today's webinar on understanding legal frameworks for cooperative housing. Insights from the ILRAI report. I am Andrea Naku. I am the Secretarial Coordinator of Cooperative Housing International. And it is my pleasure to welcome you all today. This has been quite an anticipated report, so I think this discussion, is even more welcomed. Just a few housekeeping points. The session will be recorded and we will share it through our channels later so that those who couldn't join us today will still be able to take part in the conversation. You are welcome to use the chat. It's the easiest way to collect your questions, as in case any will be unanswered, we will be able to save them for later. There will be, if on the program you see that there is a discussion segment, but feel free to share your questions as soon as they pop up. Yes, I think with all this, we are ready to go. Just a quick introduction from my side, because I understand the topic. I'm working on it every day, but I'm still quite far from the very precious and in-depth expertise of our speakers today. So why did we get here? Why did we have this report made? Unfortunately, housing system across all regions are facing growing pressure, from affordability challenges to unequal access, to questions around long-term sustainability and community control. At the same time, cooperative housing continues to take very different forms across countries and regions. In some contexts, it is deeply embedded in housing system and public policy traditions. In others, it is still struggling to gain recognition or access to finance, institutional support. So this webinar aims to open a comparative and international conversation around all these realities. And rather than aiming for a single solution and model, we will try to explore what conditions allow cooperative housing to emerge, grow, and most importantly, endure over time. This discussion is based on the Law on Cooperative Housing report, which my colleague will share with everyone in the chat in case you missed all the click here messages. And this was developed through an initiative together with the International Cooperative Alliance and support from the European Union. But my colleagues will give you more details on that. Without further ado, we'll hear from some of the coordinators and contributors behind the report itself, and they will help us unpack as much as we can in 2 hours the broader findings and the themes emerging across some of the regions that we have here today. Now I would like to give the floor to Julie Lapalme, the one from whom I took over the very important mission of coordinating Cooperative Housing International. She has dedicated more than 30 years to cooperative and nonprofit housing sector. She held leadership roles with the Agency for Cooperative Housing and CHI, supporting the sector development, knowledge sharing, and international exchange. And she currently administers the Greener COP Migrant program of the Cooperative Housing Federation of Canada. So, Julie, the floor is yours.
Thank you, Andrea. I will just share my screen. Great. Are we good with the presentation?
Yes, we can see it.
Yes. Okay. All right. Okay. All right. Thank you, Andrea. Thank you for inviting me to this webinar, and thank you to all the participants who are here today. As Andrea mentioned, I am the former Secretary General of Cooperative Housing International. I was working with CHI for 11 years, and then worked on the ILRAI project for almost 2 years. So happy to see it come to fruition and to come to this moment where it's being presented in this webinar. Okay. All right, so what does ILRAI do? It gives us a common language for comparing laws that were never designed to be compared. Cooperative housing is increasingly presented as part of the answer to the housing crisis, but the legal foundation is not very well understood in some places. Right now, the evidence is scattered across many countries, many legal systems and policy areas, which makes comparison a little bit difficult. But ILRAI is an opportunity to build a clearer legal map, what exists, what works, and where the barriers lie. It can help identify the laws, institutions, and policy tools that enable cooperative housing to grow. It also gives advocates stronger evidence. Instead of relying only on examples or anecdotes, we can point to patterns across countries, and we will see those in a bit. For policymakers, the goal is practical. It shows what needs to change in the law, in finance, in land access, and implementation, so that cooperative housing can be supported more effectively. So how the ILRAI report was developed, it started with a questionnaire. The work was built as a collaborative and a comparative research process. It was a collaboration between the ICA and NCHI, particularly with the help of Santosh Kumar, the Director of Legislation. We started by designing a shared research framework that could be used across different legal systems and housing contexts. A common questionnaire was developed to collect comparable information on housing cooperative laws, policies, and support systems. The questions focused on key areas such as legal recognition, tenure, governance, finance, taxation, asset protection, and alignment with public policy. We also reached out broadly across regions, contacting more than 60 cooperative housing federations, legal experts, researchers, and sector partners. In total, we gathered input from 20 countries, including Canada, the UK, Zimbabwe, Uganda, India, Sweden, Tanzania, and more. The goal was not just to collect examples, but to create a clearer basis for comparison across countries. This research was supported by legal experts with experience in cooperative and housing law. We worked with Tomasz Mazek, who's here with us, a lawyer and scholar at Adam Mickiewicz University in Poznan, I totally mispronounced that, in Poland, and Ajibola Akanji, an attorney and lecturer at Lead City University in Ibadan, Nigeria, who also contributed to the legal review. The work included a review of legal and policy materials from different countries. We looked at cooperative legislation, housing laws, financing tools, tax treatment, dispute resolution, oversight, land access, planning, and building rules. The comparison included countries with dedicated housing cooperative laws, as well as countries where housing co-ops operate under broader cooperative or housing legislation. So this helped us to see not only what the law says, but how different legal systems make room for cooperative housing or how they fail to do so. The analysis used a comparative framework drawn from the questionnaire to assess how supportive each legal environment is for cooperative housing. So the goal was not to rank countries simplistically, but to identify where the law enables cooperative housing and where reform is needed. The research looked at a set of key legal and policy dimensions that affect whether cooperative housing can develop and remain affordable over time. First, we examined whether the law clearly defines housing cooperatives and recognizes their specific status. We also looked at how easy it is to establish and register a housing cooperative because complex or unclear procedures can become a major barrier. Governance was another core issue, especially whether the legal framework protects democratic member control. The review also considered how cooperative assets are protected and whether the law supports long-term affordability. Finance and taxation were important dimensions, including whether housing co-ops can access suitable funding and receive appropriate tax treatment. We also looked at dispute resolution, oversight, and how well cooperative housing is connected to broader housing policy and public programs. And finally, we considered whether governments collect official data on the sector, because without data, it is much harder to design policy or measure impact. Good legislation matters, but is not enough on its own. Housing co-ops need a clear legal form so governments, lenders, and members understand how they are established, governed, and protected. They also need patient finance, loans, guarantees, or funds that fit long-term affordability and cooperative tenure rather than short-term profit models. Land access is also equally important. Public land, land trusts, and long-term leases or acquisition tools can make projects possible where market land costs would otherwise block them. And finally, co-ops need movement capacity, federations, training, auditing, and peer support to keep them democratic, accountable, and financially sound. So the main message is simple. A law can open the door, but institutions, finance, land, and sector capacity are what really build the ecosystem. So to conclude, ILRAI is a better way to is a way to better understand what cooperative housing needs in order to function, to grow, and remain true to its purpose. Going into this, we knew that strong cooperative housing systems need legal recognition, secure tenure, access to suitable finance, clear governance rules, asset protection, and public policies that understand and recognize the cooperative model. My role was simply to connect the housing cooperative movement's practical experience with this legal research process to make sure that the report speaks not only to lawyers and policymakers, but also to the federations, cooperatives, and the communities trying to make these models work on the ground. So I will now hand the floor over to the experts who can take us further into the legal substance of the report and its wider implications. Thank you very much.
Yes, Julie, before letting you off the hook, because I know you won't be able to stay for the full session, just one question that I thought while preparing all this. After having reviewed and connected all those dots, what would be the biggest misconception that the sector is facing from policymakers? Because yeah, you just said that laws are necessary, but also they're not sufficient.
Yeah, the laws are there to enable the provision of or the development of cooperative housing, but you also need the enabling framework from the federations as well, from policymakers. You also need to have some systems in place for acquiring land, and for for the financing. Whether the laws are there or not, you still need to have the enabling financing mechanisms to make the cooperative housing get started, get off the ground, and get the shovels in the ground. And so the laws are just one aspect of it. But the land tenureship is another, and the federation system is another. It's hard to build a housing co-op on your own. You need to have those support systems, from legal, finance, the federation infrastructure, as well, to make it all a success.
Okay, thank you so much for being here, for your insights, and yeah, I hope you'll be able to enjoy the rest of the sessions, however long you can stay with us.
Yeah, thank you. Yeah, I will have to slip out shortly, but I'll stay a little bit longer.
Great, thank you. Um, and now, indeed, we are moving along to let's say, one of the pillars that supported the work of this on this report. So we have Thomas Marcet, PhD and a lawyer and researcher at the University in Poznan. His work focuses on cooperative law, particularly on housing and energy cooperatives, and he has contributed to national legislation, legal advisory work, and international research initiatives within the cooperative movement. So the floor is yours, Thomas.
Thank you very much. I hope that you can see my presentation. So Julie told us about the methodology about our project. I will elaborate more on the legal aspects and the conclusions of the report. As you have already been told, we have received 20 questionnaires from 19 countries, because there were 2 questionnaires from Canada. You can also see the participation of each regions, because we have divided the answers according to the regions, and of course the objective of our project. And to tell you more about the results, starting with the Europe, we have learned that in Europe, housing cooperatives are the most stable there when there are dedicated laws and regulations governing the housing cooperatives, and where are the strong audit traditions. In the countries where cooperatives rely mostly on the general cooperative law or even the company law, when there is no dedicated legal act for legal cooperative law, the recognition is thinner, and the practice must fill the legal gaps, and there are also many problems with interpretation. There are some cases where the practice differs from the legal regulation, which is a concern for the responders. Also, finance is the main constraint because cooperatives avoid speculative investor capital, so they need the long-term tools which should be provided by the governments, and also in Europe, governance is still democratic and strong, but as the cooperatives grow in members, there's a need not to lose real control over the decision making. For example, the one member, one vote rule should stay as a standard. For example, Austria and France show the benefits of dedicated legal regulations and audits, and by contrast, Belgium and the United Kingdom, the response showed us how relying only on the general law leads to thinner recognition and more uncertainty in practice. Going to Africa, most countries there still use general cooperative laws, only with the few housing specific provisions. And also the responsibilities are split between the cooperative registrars and planning and building authorities, which makes the compliance harder, as we have learned. And the tightest constraint in this region is access to long-term project finance, and also responders showed us that the tax and land policies can be uneven. Therefore, the direction of the reform is clear that for most, the housing cooperative rules should be explicit and should give the guidance. And also, there's a need to create dedicated funding tools. Speaking about the Asia Pacific region, their housing cooperatives rest on cooperative law and also one member, one vote principle, but many operational details are left to bylaws, and that was mentioned as a problematic matter. The internal democracy is strong, as we have learned, but the oversight and finance inconsistent was showed that it is connected to the particular programs, and also the agenda for that region, as we saw, that is the legal clarity once again, and reliable cooperative financial programs. Also, some tax matters were took as a concern. Speaking about the Americas, their most systems use also general acts regulating cooperatives. There should be mentioned Uruguay as a notable exception, with a major housing cooperative law, strong asset law protections, and also public financing. It was mentioned in the questionnaire. Elsewhere, the internal democracy is strong, but also it is a problem about the particular programs, about finance inconsistency. Those aspects were mentioned as a problems. As we see it, our key finding is that when the law clearly recognizes the cooperative identity and also aligns finance oversight, taxation, and data with the cooperative identity, housing cooperatives can provide affordable and stable homes under democratic control by residents. And it is important that the dedicated financial programs should be taken into action, but only if the cooperatives really are aligned with the cooperative identity, because they should not be used by the particular investors, by the particular members. Also, we have identified the barriers for the housing cooperatives. First is, of course, the legal recognition gap, as I mentioned. That I think it's quite clear. Also, finance mismatch, the need for the financial programs were mentioned quite unanimously. But as we see it, the argument for the financial programs is that cooperatives really should work with the identity and really work for its members, especially in the impoverished regions. Also, the third barrier, as we see it, is the fragmented oversight and weak data. As Julie also mentioned that, because multiple authorities increase the transaction costs and slow the delivery. So limited data also makes it hard to create the policy, and especially we showed that we saw that in the Belgium response. So with that, we would like to present, and we have presented in the report, four key recommendations. First, to recognize housing cooperatives explicitly and the legal system, especially with the dedicated legal acts, of course, in the systems which are based on legal acts rather than the precedents. Second is to build finance and land pathways to make it easier, especially for the cooperatives who care for the impoverished regions and communities. Safeguard identity and governance, because, as I said, cooperatives shouldn't be used as a vehicle for the investments for the actors. And the fourth is to embed the cooperatives in strategy and data within the policy making process. And that leads us to the conclusion. So, on the basis of the answers of our national experts, we saw that we have confirmed that where the law, finance, and policy are coherent, housing cooperatives become a stable pillar of the housing system. Of course, the ideal solution, ideal system right now is quite unreachable, so to say, as it is the standard. But we see which aspects work for the stability and prosperity of the housing cooperatives sector. And when those aspects are met, housing cooperatives produce affordability at cost, they protect assets for community use, and also democratize the housing decisions. And we see that in places where the cooperative identity is written to law and supported in practice by the policy making, especially in those regions, cooperatives operate where cooperatives operate only under the general law, there are uncertainty and underinvestment. And so, speaking about the details, I would like to ask you to look at our report. And thank you very much. If there are any questions, I'll be happy to answer them. Thank you very much.
Thank you very much, Thomas. For the moment, we don't, the chat is still warming up, so to speak. We will have, but we will have time towards the end during the discussion part to yeah, touch on maybe some more important key points. So now we will go to our last speaker for this segment, Santosh Kumar. from the International Cooperatives Alliance. He's the director of legislation, and since joining ICA in 2010, he has worked on cooperative law and policy at the global level, supporting legal and institutional frameworks that enable cooperative development. So, Santosh, the floor is yours.
Thank you very much, Andrea, for the kind introduction. To be absolutely honest with our guests, we are trying to build a legal office at the ICA that can serve its member organizations sufficiently. And this initiative, and I really thank the CHI board and members for collaborating with the ICA, is a step towards offering better services to our member organizations. So by no measure am I an expert on housing cooperatives, but certainly working with Thomas, Julie, and Ajibola on this report was a step towards becoming more knowledgeable about the subject. So for that reason, I am going to stick to only the, let's say, international law realm that concerns housing cooperatives. But maybe at the beginning, let me offer warm cooperative greetings from our president, Dr. Ariel Guarco, our director general, Mr. Jeroen Douglas, and the chair of the Cooperative Law Committee, Professor Hagen Henry, who was supposed to be here, but due to an unforeseen circumstance, he had to miss today's participating in today's webinar. So he conveys his best to all of you. And also, a special thanks, let's say, to Blaise Lambert, who's a board member of the ICA representing the housing sector, for having faith in this project and also for organizing this webinar through the Secretariat. My presentation is structured in 5 main pillars. I'll provide a brief introduction to my to the international law angle at the beginning. Then lay emphasis on the need for distinct the recognition of the distinct personality of cooperatives in law. Thereafter, the international standards that cooperatives have achieved for themselves through self-identification. And then I'll speak about sustainable development as a principle within law, and also human rights, and how housing cooperatives are relevant to these discussions. So first and foremost, it's important for us to acknowledge that housing is a fundamental and basic need, and there are fundamental and basic rights associated with housing. And this is affirmed by the Universal Declaration of Human Rights, Article 25, also by several highest courts, national courts around the world, and among them, the most important, let's say, are the South African decision or in a case called Groot Broom, and also the Indian Supreme Court in a case called Olga Tellis versus Bombay Municipal Corporation. In addition to the Inter-American Court of Human Rights in a case called Yaqui Aksa Indigenous Community versus Paraguay, where these high-level courts unequivocally confirmed that the right to life, the fundamental right to life, comes with the right to life with dignity, and the right to adequate living conditions. So it's more or less settled, I must say, a legal principle that no right to life can be complete without the right to adequate housing, right to adequate living conditions. Now, the European Social Charter also, under Article 31, guarantees right to housing. Now, of course, the right to housing around the world has graduated in some parts of the world from a fundamental, absolute, irreducible right to a constitutional right, which is slightly lesser in its effect. However, still the states are, the governments, national governments, regional governments are indeed obliged to ensuring that their citizens have a right which is a right to housing which is adequate. We also have seen in the report that these rights, despite being constitutional, And this is the case from Nigeria. They're constitutional, but they are mentioned in the non-justiciable part of the constitution, meaning these are higher aspirational ideals that the state policy ought to be taking inspiration from. But coming back to the international community which has articulated its most recent general policy on housing through Agenda 2030 on Sustainable Development, or the SDGs as we know them. SDG 11, as you know, is directly on housing. However, there are several SDGs that have indicators and targets that concern the right to adequate housing and right to settlement. Cooperatives, as you know, are already acknowledged in the Agenda 2030 for sustainable development in two parts. And I think the most important takeaway for the cooperative movement from the Agenda 2030 is that cooperatives in 2015, when this agenda was adopted, were recognized as part of the diverse private sector, thus dispelling any myths or any misconceptions that they are the extended arm of the government or the state, or at the same time, nor are they part of profit pursuing joint stock company type of private sector. So it's part of the diverse, evolving private sector. And the recognition or support endorsement from the highest policy assemblies in the world, including the UN General Assemblies, have recurrently recognized cooperatives as vital actors in social development. Now, staying within the UN system, the United Nations Human Settlements Program, or UN Habitat, is the one that deals specifically with housing. And the Quito Declaration of the conference of the same name, Habitat 3 as it's called, is the most recent conferencing instrument that has urged states to firstly reiterate their commitment to sustainable, inclusive urban development and support for cooperatives. Secondly, to expand affordable options, including rental, cooperative housing, co-housing, and community land trusts. And thirdly, to develop housing finance products to boost supply of housing and prevent evictions of tenants. Now, it's no longer a secret that the housing crisis is omnipresent in every country that we have reviewed in the report. We did receive information that pointed at a growing crisis, a housing crisis, especially in urban neighborhoods. And the shortage of, legally speaking, the shortage of adequate housing is in violation of Article 11 of a legally binding convention, the International Convention on Economic, Social, and Cultural Rights of 1966. And it's in violation because the Article 11 of this convention, which is ratified by 173 member states of roughly 200 member states of the UN, imposes obligations on states to progressively realize the right of individuals to safe, secure, and affordable homes. And again, speaking legally, if the state in question fails to demonstrate that it has not fails to demonstrate that it has it's not undertaken cooperative options, then it's in further violation, I would say, of this international commitment and ratification, as I mentioned, which is in 173 countries. So all of this is expected to lead to strengthening the legal advocacy of cooperatives. And for that, the most important thing is that cooperatives are recognized as the distinct personality of cooperative enterprises is recognized in law, meaning the various aspects of cooperative organization, governance, promotion, etc., as is articulated in the ICA statement on the cooperative identity, must be translated into adequate rules and laws by member states. Now, the reason why we chose housing as the first sector to collaborate with for the International Law Research and Analysis Initiative is because housing is among those sectors that is subject to multiple regulatory oversight. You, of course, have the housing the cooperative regulator, or the organizational regulator, then you have the sector regulator as well. So the UN has on more than one occasion informed governments to have a general law on cooperatives, but complement that with specific chapters and specific sections on specific types of cooperatives that particularly draw the attention of more than one regulator. So housing is one of the first ones, let's say, that sort of have more than one regulator, and we thought it'd be interesting to have a global, at least begin a globally comparable analysis of laws that affect cooperative housing. We do see that. Well, it's common sense actually that if we don't, if there is an absence of legal and policy recognition for the distinct personality of cooperatives on the one hand, and cooperative housing on the other, then it becomes the sector itself, housing cooperatives themselves in that given jurisdiction become less competitive. I did mention how cooperatives have been recognized as part of the diverse private sector, but that is not to convey in any way that there is an essential role that the state has to play in ensuring that housing cooperatives are adequately supported, proportionately regulated, and promoted among the people that require such housing. Now, as most of you would already know, ILO Recommendation 193 on promotion of cooperatives is the most important international law instrument that we have for cooperatives. It's a recommendation. It is soft law. It's persuasive, sure, but it comes with legal obligations. And soft law is at the international level is much better than having no law at all. So we do have an international, let's say, consensus. It was the recommendation 193 was adopted almost unanimously and by the International Labour Conference in 2002. So we have this as a labor standard international law that promotes cooperatives, and at the same time we do also have the international ILO's recommendation 115 on workers' housing that clearly identifies housing cooperatives as a tangible option for to meet workers' needs during their employment. Now, it will be incomplete to mention these standards without reflecting upon our own standard, which is the set of cooperative principles, values, and definition. And Principle 6, cooperation among cooperatives, is extremely important, is what we felt while coordinating this report through the work of the apex federations, apex cooperatives, the representative bodies at the national and local level, and of course the international level, in achieving the policy goals of the movement. The other important international legal instrument is the 2001 UN guidelines aimed at creating a supportive environment for the development of cooperatives. Quite wordy, but we just call them UN guidelines from 2001, which establishes a very important principle. It says that governments must not enact laws that disadvantage cooperatives because of their specific characteristics. So in one line, it says that the governments have to firstly acknowledge and recognize the specific characteristics of cooperatives, and that no law passed intentionally or unintentionally must not have a consequence that affects the cooperative in a negative way, specifically because of their special characteristics. Now, at the same time, the ILO recommendation 193 and also the UN guidelines, and also if we zoom out to the main source of international law, which is the Statute of International Court of Justice, Article 38, equal treatment is extremely important for us to rely on, because on the one hand we are arguing that cooperatives must not be disadvantaged for their specific characteristics, but at the same time we are well within our rights to argue for equal treatment, treatment equal to other forms of enterprises, including in the housing sector. So if there is a certain measure that is extended to a housing association or housing companies, LLPs, etc., the same should be at least extended to cooperatives. But at the same time, of course, the cooperative special characteristics have to be taken into account, and the law has to be developed in that sense. One example I could give you is, of course, we talked about asset lock. Thomas mentioned asset lock in Uruguay, and other countries also have such reserves for posterity, for the future generation. But it's also taxation also becomes an important area, and also public procurement, but taxation particularly, where on the one hand you want cooperatives to play at the same level as other associations or enterprise forms, but you also want the state to recognize the special treatment that cooperatives rightfully deserve because of the way they are structured. Now, staying within the realm of standards, the ICA statement, of course, as you know, it was developed bottom up. It was a review of the cooperative principles that led to a statement, and the statement was adopted by representatives of 700 million cooperators in 1995, and since 2001 and 2, this has entered into the realm of international law. But it's also important to acknowledge, recognize, and appreciate the Cooperative Housing International that in 1995 offered through its members, its own interpretation or a declaration on the ICA statement of the cooperative identity, which, of course, speaks to or covers all types of cooperatives around the world. Cooperative Housing International was I think prompt enough to develop its declaration on interpreting the statement in words that would speak to housing cooperators. So it has a definition. I invite you to read this declaration by CHI, where they have offered a definition, values, interpretation of the principles, etc. And here, it's important that self-identification of the standards and which are getting developed into international standards are useful for our advocacy, legal advocacy. Now, for the purposes of my presentation, the most important part of this declaration by Cooperative Housing International was on the seventh principle, concern for community. And the declaration states that cooperative principles enable members to aspire to solidarity and social peace within a broad community of cooperators that radiates outward from the single cooperative to the international commitments of worldwide movement. And within the concern for community and within brackets, parentheses, future generations, the declaration also guides housing cooperatives within its wider membership to offer best quality service at a fair price to its members, and also establishes that housing cooperatives are part of a wider or a larger community, and that these units of dwelling must uphold principles of social justice in all their affairs. So these are important indicators to sort of convey to governments or policymakers that these are not housing units alone, and not only are they simply schools of democracy, but they're also bastions and champions of social justice, basically trying to help assist the state in achieving these goals. Now, taking that as an inspiration and zooming back to our report, the seventh cooperative, and talking about the seventh cooperative principle, which essentially marries the concepts of sustainable development and democracy. Because if you remember, it's the explanatory note to the seventh principle reads that cooperatives work towards sustainable development of their communities through policies approved by members. So it's essentially bringing sustainable development to the nano level, to the micro level, where at the local level rather, instead of only the United Nations or the international community telling or establishing what sustainable development is. So it's essentially it's a really powerful, I think, principle which the CHI have adequately elaborated. So we had asked a question in our questionnaire about how sustainable development is met in the law. Is it included or not? So it's what we found that social sustainability is the most developed dimension, inclusive membership, democratic practices, community cohesion. We see these things established in law for a long time. The environment sustainability aspect is emerging. It's uneven. We see the so-called advanced economies already sort of including environmental sustainability aspects in laws or in bylaws or the whole spectrum of the laws that govern housing cooperatives. However, that's not the case in other parts of the world. We did find that cooperative principles, including cooperative principles within the text of legislation, public policy, or even bylaws, is a clear indicator that for the housing cooperatives to have a sustainability anchor, to have a reference point to pursue sustainability goals. As I mentioned, the environment sustainability aspect is emerging, but it's fragmented. The same goes for public policy. Usually, as we know, public policy and law speak to each other. One comes after the other. So we also find that public policy is not uh, so well developed for housing cooperatives insofar as environmental sustainability is concerned, or really elaborating or translating the seventh principle into legal rights and responsibilities for both the cooperator and the cooperative. So this is, let's say, an implied call for the Cooperative Housing International and its members to elaborate the seventh principle, translate it into legislation for your members. Now, moving from sustainable development as a matter of right to human rights, we see that the strongest cooperative housing sectors tend to exist where housing rights are supported by legal frameworks that complement land access, finance, tenure, security, and cooperative development, and not merely exist as registration legislation. So legislation only to register, and that's it. So we see when the sector becomes stronger when the law or the public policy and the public policy take into consideration these additional allied laws or allied aspects of housing as a sector within the main cooperative law or policy. And as was mentioned by Julie at the beginning, just recognition of housing as a right is insufficient, and it needs an ecosystem to thrive, to be implemented, to be justiciated, and that's possible through enabling institutions and financing mechanisms. Now, we concluded that all surveyed countries do operate within a framework that's influenced by either an international or a regional human right instrument. So we try to see through the responses to the question around how if the housing cooperatives can be viewed as advancing human rights. And there we see Canada and Uruguay as standing out, where the right to housing is adequately mentioned within the text, either of the legislation or the constitution itself. Now, they are not the exceptions. Other countries as well do mention right to housing on the one hand, and also the right to form cooperatives, or cooperatives are mentioned in the constitution. However, these kind of recognitions or mentions in the constitutions don't themselves automatically translate into enforceable rights. And this is what I spoke about at the beginning in the case of Nigeria, that we do have this in the constitution. However, this is in the non-justiciable part of the constitution. So it's more like an aspiration and ideal to pursue. And we also found that in Quebec and British Columbia and Canada, they rely heavily on tenancy protections, occupancy rights, and discrimination frameworks. And here we see a high level of protection indirectly through broader human rights and social protection legislation. We believe that ILRAI for the Housing International was a beginning. We hope to do a part two, maybe after consulting colleagues at the Housing International, and also to see if there is interest from countries that have not been featured in the report. And of course, the ICA remains committed to assisting the Housing International. And for your information, two final points. One, that we have the ICA, through the partnership with the European Union, we have launched the legal framework analysis, which essentially results in national reports on the general knowledge about cooperative legislation in countries. So we've, in the previous cycle, we had done an analysis of 79 countries. And in this cycle, we hope to cover more countries. Maybe we reach close to 130, 140 countries by the end of the project in 2029. And the research and analysis initiative will continue. From housing, we move to financial cooperatives, and in 2027, we will release a similar report for financial cooperatives. But obviously, one of the earliest financial cooperatives were also set up, I believe, to build houses. So there is obviously an intrinsic link between the sectors, among the sectors that we're working on for this legal research. So I would thank you for the opportunity, Andrea. I'm sorry if I went a bit above the time allocated to me.
Thank you so much, Santosh, for this very comprehensive overview. I think it's needed to have a good foundation. If it's all right for Ajibullah, I would first give the floor to Blaise. We will have time for questions and more comments after that, as I know he has to step out at some point. And then, yeah, we will continue. If it's all right, Blaise, who is the Chief Executive of the Confederation of Cooperative Housing in the UK, member of the ICA board, and treasurer of CHI.
Thank you very much, Andrea, and can I also thank our opening speakers in today's session for their wide-ranging presentations. I'm going to speak to the UK situation. So in the UK, housing cooperatives are subject to general cooperative legislation. Specifically, the most relevant piece of legislation was created in 2014, the Cooperative and Community Benefit Societies Act of 2014. This legislation frames relevance to all forms of cooperative activity in the UK. There is no specific cooperative housing legislation. And as was discussed earlier on, where there is the lack of that specific cooperative tenure relationship in law, cooperatives struggle to be as effective as they are in other countries. And we see a very clear difference between the UK picture and the picture in many other Western European countries that have specific cooperative tenure, and therefore the ability for the creation of appropriate financing mechanisms and policy frameworks that enable substantive growth. Housing cooperatives in the UK essentially are subject to general contract law. So because there is no form of cooperative tenure, our tenancy agreements essentially sit in general contract law. At the same time, housing cooperatives are subject to a number of other pieces of legislation that impact on them, such as general housing law, equalities legislation, human rights legislation, antisocial behaviour, crime and policing legislation, care legislation, data protection, and broad social housing regulation in the UK. We do at least have a specific legal definition. That's one line in the 1985 Housing Act that defines what a housing co-op is. That primarily exists to say a housing cooperative is this, and its residents have no right to buy their homes. That does, however, provide a distinct form of housing provider that is specifically related to shareholding and membership structure. In a fully mutual housing cooperative in the UK, all members are tenants. It's not an opt-in or opt-out option. Whereas in a non-fully mutual housing cooperative in the UK, tenants have the right to choose whether to be members or not. Housing associations, council and private landlords do not have this model of resident ownership of governance. Each member of a housing cooperative in the UK has one nominal share It has a nominal value attached to it. It entitles them to no stake in the equity of the organisation, no entitlement to dividend or profit share, and that one share entitles them to one single membership vote within the governance structure of the cooperative. There are no legal stipulations regarding involvement and engagement. Individual cooperatives will establish their own membership policies that define membership expectations and requirements, and we see a great variation. And again, this comes back to this central point of a lack of primary legislation. So we see a wide variation from co-op to co-op in terms of the expectations and requirements of membership. Housing cooperatives are governed in one of two ways. The smaller housing cooperatives are governed by what's called general meeting. This essentially is all of the shareholding members having the right to attend general meetings and govern the organisation in that way. Whereas housing cooperatives, once they get past a certain size, and we tend to find that threshold is somewhere between 40 and 50 members, they move to governance by management committee or board, where the general members will elect a smaller subset of members to govern the organisation in a committee or board structure. Cooperatives are also able to co-opt non-members onto their governing bodies, specifically in those co-ops that have management committees or boards. Those co-optees will hold the same legal responsibilities as other members of the governing body structure, usually subject to a maximum outlined in the cooperative's rules of 3 such co-optees. The only mandatory member contributions to share capital is the nominal share that I spoke about earlier, that usually has a value of £1. So the member, when they join the cooperative, they pay £1. That is their membership stake. There are no other mandatory or discretionary contributions, as housing cooperatives do not issue share capital beyond that £1 membership share. The key legal change that we would benefit from substantially in the UK, as I've touched earlier on, is the introduction of a cooperative housing tenure, a distinct form of tenure. There are no legal barriers in the UK to cooperatives developing, but it's difficult when there is no basis in law for the tenure type. And that makes it very challenging for the financial community, the lending community, debt markets, and the like, to understand what they're being asked to lend to. How do we resolve disputes? Well, disputes with other corporate entities and governmental bodies can be resolved through the courts and arbitration services. Cooperative rules and internal policies will usually apply to member disputes, although recourse to the courts is available. Those cooperatives, those housing cooperatives that are registered providers of social housing in the UK, in other words, those that have received government funding to develop low-cost housing, are subject to the jurisdiction of the regulator of social housing, and their disputes and complaints are therefore subject to the jurisdiction of the Housing Ombudsman Service, which exists to resolve complaints and disputes within the broad registered provider of social housing sector. The Cooperative and Community Benefit Society Act of 2014 requires that cooperatives approve and submit their accounts to the Financial Conduct Authority, which is another layer of regulatory body that we have in the UK. That is the registering body for all cooperatives. It is that organisation that sets rules and exemptions to different levels of audit. However, the broader regulatory environment of what housing cooperatives do in terms of their trading activities, in other words, landlord services, are either governed by the regulator of social housing, or for those organisations that are not registered providers of social housing, they're subject to the same very limited level of regulation that there is over our private rental sector and home ownership sector in the UK. We have no funds created at government level to provide educational and promotional funds for cooperatives. Housing cooperatives are subject, as I said earlier on, to a number of related areas of law, including the Human Rights Act of 1998, and we've heard quite a lot spoken in the earlier presentations relating to the basic and fundamental human rights relating to housing. But In the UK, that only extends so far as to prescribe the rights of individuals to a home and the peaceful enjoyment of that home, not to any collective right for communities or collectives, and it does not apply to land use in the UK. There is no legal stipulation or restriction on objectives and activities, although rules must be approved by the UK's government's Registrar of Cooperatives, the Financial Conduct Authorities. Fully mutual housing cooperatives can only trade with their members, but non-fully mutual housing cooperatives can trade with non-members as well. The restrictions in place of setting up cooperatives are fairly enabling, to be fair. To establish any form of cooperative in the UK, there must be a minimum of 3 founding members, and there is no maximum number required. If the number falls below the minimum, the cooperative's rules will set out the necessary steps to return to the minimum number and interim measures whilst those steps are being undertaken. General provisions relate to the termination of membership. So moving on to talk about how membership is terminated or people cease to be members of co-ops. Well, clearly in a fully mutual housing cooperative, you no longer live there, you're no longer a member. So I used to live in a housing cooperative. I used to be a member of one, but I'm not now because I no longer reside in one. General provisions relate to the termination of membership that apply to all UK companies, such as death and bankruptcy. Individual cooperatives rules will relate to membership ending when a tenancy ends, and will have additional criteria within those rules relating to termination that link to membership requirements. But again, as I said earlier on, those membership requirements will differ fairly significantly from cooperative to cooperative. Because there is no cooperative housing tenure law, occupancy rights are exclusively defined within the contractual tenancy that the individual co-op will agree with its tenant members. And again, there is fairly substantive difference between the tenancies that different housing cooperatives are issuing, because they are essentially contracts that are drawn up between the individual members of each individual co-op and that co-op. Those tenancy rights are determined by the service of a 28-day notice to quit. And the tenant members of cooperative housing cooperatives in the UK have no additional security of tenure beyond that 28-day notice to quit period. Their shares are non-transferable and non-withdrawable. The law provides no legal separation to surplus funds and no prescribed legal reserve or restrictions or definitions relating to the use of surplus funds, other than they must be used for the furtherance of the objects of the individual cooperative. I'll speak very briefly now to tax legislation before wrapping up. Housing cooperatives are subject to the same taxation regimes as other corporate entities in the UK. There are some areas where cooperatives enjoy slightly different treatment, such as stamp duty, land tax, annual tax on enveloped dwellings, and corporation tax. As was said at the outset, I'm the chief executive of the UK's federative body, trade body for all housing cooperatives. We have just over 215 member cooperatives within the confederation in the UK, and part of our role very much is to help cooperatives access examples of good practice. We publish 5 sets of model rules for different types of cooperative, a code of governance, and detailed governance and management guidance that provide a framework for good practice. There is no central government collation and publication of data, although we as the Confederation do hold a wide range of data. General data is collected through an annual return that is submitted to the Financial Conduct Authority, and that data is published, but published on a co-op by co-op basis on the online mutuals register. The social housing regulators in the various nations of the UK collect monitoring data, but again, this monitoring data is used for internal monitoring purposes by the regulator and is not published in a singular and easy to understand format. Well, I hope that's given you an overview of the legal framework or the gaps in legal framework within the UK. I hope that the rest of the session goes well. I have to disappear now to go and jump on a train to London, but I will be rejoining the session on my mobile phone, hopefully from the train. So look forward to enjoying the rest of the session. Thank you.
Thanks a lot, Blaise, and fingers crossed for catching your train and joining us later. Okay, so now we move to our next speaker. He's Mr. Ajibola Akanji from representing the Africa region and more specifically the context of Nigeria. He is a barrister, lecturer, and a member of the ICA Cooperative Law Committee, and his work focuses on cooperative law and legal frameworks supporting cooperative development in Africa. So if you are ready, over to you for another context.
All right. Good evening, ladies and gentlemen. Thank you very much for the kind introduction. My name is Ajibola Anthony Akanji. So I've been properly introduced by the program anchor, and I understand I have just about 10 minutes, but I have a lot of drafts to deliver, so I'll make it as short as possible.
Yes, yeah, then we have time for some questions later. So yeah, do not worry.
All right, thank you. So now basically for this session, it relates to from research to practice, with focus on reactions to the report findings, regional perspectives, relevance across different housing systems and cooperative traditions. Now, research to practice basically brings forward the interplay of science and policies. And as you have observed with the earlier speakers, Santosh Kumar, Thomas, Blaise Lambert, and the other speakers, a lot has gone into this report. And the report is a product of intensive research that cuts across about 28 countries, etc., and the 4 regions of the ICA. But how can we transfer these research findings? How can it metamorphose into practice? The very first thing is to look at the peculiarity of each country. I participated in the report, and one of the things I could see is that there are no perfect similarities among the countries. Even within Africa, where we have Nigeria, Zimbabwe, and Tanzania, and one other country, you still realize that it's the same Africa, but then the peculiarities, the differences are more or less profound. So it creates a problem. So you can't say, oh, this is basically an African problem. There are problems that are specific to each country, even within a particular region. So now, how do we promote these research findings and make sure that policymakers adopt it? Now, it starts from identifying the peculiarity of each country. We have realized among the four regions that we are evaluated that it appears by statistical standard that the European region seems to have adopted research outputs into their policy and legal framework over a period of time than every other country. I say this because when you listen to Mr. Santosh Kumar, the laws he was mentioning, it appears largely that the cooperative housing laws in Europe have more similarities, have taken in more ingredients of those laws than every other country. And when you look at the Americas too, it seems, of course, there are identifiable problems. There seems by every standard that they have also adopted more from international frameworks into their national legislation. The problem lies more with the Asian subcontinent and Africa. So these are the regions where you see that research findings, scientific outputs have not really been adopted into practice. Now, why do we have this kind of challenges? Why is it that, research outputs on cooperative housing are not being adopted into national policy framework? Now, one of the first things to look at is that housing in itself is an interplay, is an area, is a field of endeavor that is more like a pool whereby different frameworks of law, different standards of law comes into it. Land law, family law, taxation law, financial law, etc., etc. I've used the word family law to cover areas of inheritance and tenure system. In the land law in every country may look similar, but they have pronounced differences. For example, the word fee simple that we lawyers normally use has different meanings across different countries and across different jurisdictions. It's the same with family law. Who inherits land? How can land interest be moved from generation to generation? That is from father to children to grandchildren, etc. Then the ease of sale, of using land as collateral security, that goes to financial law. Taxation, the law on taxation is different across many of these countries. Now, the reality is that the differences are there simply because there are different stakeholders across different jurisdictions. And I will reduce it to Nigeria, for example. Cooperatives, housing cooperatives is traditional to the people. But then, over a period of time, individuals learn to live outside of their clan. The implication is that the idea of communal living has, over a period of time, been drastically reduced. One, by socioeconomic realities, then law stopped supporting it because we adopted British laws, which in the sense of its adoption is never truly receptive to communal ownership of housing. So the average Nigerian started learning to own house as individuals. Of course, you can own house as an individual, then the ownership upon demise can reverse into the family. You have similarities too in countries with British system of law, Zimbabwe, Ghana, Tanzania, etc. But along all of these countries, you will still find pronounced differences. Now, what could be the way forward? The way forward, in my assessments, and I think a part of the report actually identifies that, is inconsistent advocacy on research products. We need, like this report, it needs to be properly advertised. It needs to be taken to beyond the cooperative movement, and the report needs to be submitted to policymakers. How well have we advocated for the reforms in law, national legislation, regional legislation on housing and on cooperatives? Please remember that to a very large extent, most, if not all, of the cooperative laws in Africa actually does not recognize housing cooperative in a strict sense. What is recognized is housing law on the one hand and cooperative law on the other hand. So there is need for advocacy for synergy. We have identified this challenge in the report, but how can we transform this research into practice? Advocacy, proper understanding of the political economy.
Oh shit! James, I can't actually. It's going to take a few days.
All right. Proper understand. Can I go on, please? Can I go on?
Yeah.
Yeah. Proper understanding of the political economy in each country. Now, when we say political economy, I will use my immediate environment, my immediate country, as a very good example of understanding of the political economy. There has been a contest between the cooperative model of business and capitalist model of business over a long period of time. Currently, there is more private sector, organized private sector investment into housing. This is the highest Nigeria and many of the African countries have ever had. Now, we must spot the difference from the very beginning. Prior to this time, 10, 5, 10, 15, 20, 30, 40 years ago, what we had in many African countries was individual building houses. Then modern cooperatives trying to come in along the line. But now we have commercial mass housing, and that's what I describe as the inroad of the organized private sector into housing. Now, the only alternative to this are the housing cooperatives. So it becomes a fundamental challenge between two conflicting ideologies. The housing cooperatives, on the other hand, and the organized private sector. That's what I think in the Western world are being called joint stock companies. So it's a contest between these two parties. Now, this contest will reflect on land law, will reflect on family law, will reflect on financial laws and financial policy, will reflect on culture of the people, and invariably it will reflect on legislation from legislation of the National Assembly to the legislation of subnational assembly on both housing and cooperatives. So it will invariably reflect on the interface between science and policy. So as much as we are doing research, we must also have a very great inroad into policy formulation and policy implementation. So at this point, I want to ask us, what do we have in plan to make sure that this particular report on housing cooperatives makes its way into national policies, national policy formulation, and are eventually executed. And it also makes its way into national and sub-regional laws. I've identified advocacy and lobbying of the politicians. You see, I'm into academics, and as much as I'm also a practitioner, I can tell that there could be sometimes a wide gap between the products of science and what happens in reality. Between these two is the interest of the major stakeholders. What does the cooperative movement represent in each of these countries? Who are those in charge of housing cooperatives? How vibrant are they when it comes to influencing policies, influencing laws? Because on the other hand, the organized private sector, which is also involved in housing, is lobbying laws, is lobbying to have policies in favor of them. Meanwhile, in reality, there is a conflict of interest between the organized private sector, who are interested in the business of housing, and housing cooperatives. So the resolution, the capacity of the cooperative movement to navigate these variables will go a long way towards having a proper research, proper research transformation on housing cooperative into practice. Yes, there are emerging opportunities. Populations are growing, particularly in Africa and the third world. Nigeria is now a country of about 240 million. There are massive housing shortages. That's an opportunity for the cooperative movement. But then there are challenges. And one of those challenges is with unfavorable law. Another, which is almost consequent, is unfavorable policies. Then behind these unfavorable laws and unfavorable policies are the interest of the stakeholders. And the main stakeholders are the competitors of the cooperative movement, which are the capitalist movements, or in another word, the joint stock company. So let me rest it here. Thank you very much.
Thank you very much. On one hand, for the homework you're giving us, but it's indeed one of the questions we ask ourselves at the Secretariat. How can we make people take this report further? So definitely this webinar is just a start of the conversation to give people a taste of what was done. And yes, to get all those questions and calls for help for mobilization out there. And it's definitely through practitioners such as you, Blaze, and the others that we hope this will get through. You are our voices on the ground. So yeah, for now, I think maybe we take the time to listen to our last speakers, and then we'll have hopefully a few minutes to throw around some questions. So yes, moving to our last speaker, Mauricio de la Vara, General Manager of Conavi Coop Chile. One of the leading housing cooperatives in the country. And with his extensive experience in cooperative housing development, he has contributed to expanding access to affordable housing in Chile and represented the sector within the international cooperative movement. So, Mauricio, if you're ready, the floor is yours.
Good morning. Good morning, everybody. Thank you, Andrea. And I hope you are seeing the presentation.
Yes, all good.
Okay. Well, thank you for inviting me to this important webinar. And in Chile, I will explain very quickly the main issues in the legal cooperatives, the framework. And one moment. We have the legal framework. We have no dedicated law to the housing cooperatives as most of the countries. Chile has no separate housing. In the law we have a specific area, some few issues for the housing cooperatives. And the cooperatives, they have a legal definition. The housing cooperatives are defined as organization whose purpose is to satisfy the housing and community needs of the members and to provide the services inherent to this purpose. It's a specific purpose for the cooperatives, housing cooperatives. We have a non-profit structure. Chilean cooperatives law established that cooperatives do not earn profit. Any surplus that we have in the year operation must be used for the cooperative's purpose or placed in indivisible reserve funds, not to remain for the members in any year, anytime. We have a third-party dealings is permitted, but in that case, must not enter in the arrangement to a tax structure that I will explain. The next. The governance is very structured in the law. The supreme organ is the General Assembly, and in the case of CONAICOP, we have an annual General Assembly with all the members that are in this moment looking for the houses. Approves the bylaws, elects directors, decide fundamental transactions, elect board of director and administrator. I am the general manager of CONADICOP. I have a board members. There are 9 board members elected by the assembly, and over all the board is the general assembly. A limited minority of non-member director is permitted. Members in the assembly one member holds 1 vote. It's a democratic control, and they decide vote for approval or refuse 1 member on 1 vote. The membership in the cooperative is voluntary, is open. If some member decided to quit about the looking the house, all the savings that are in the cooperatives, they will have all the total savings back and go to another decision for the houses. The member liability is limited to their individual amount of savings in the cooperatives. Housing rights are exercised through ownership. Transfer of membership requires board consent. Capital concentration is an important issue or article. No member may hold more than 20% of the cooperative's capital. Investor-only members are not permitted. All the members should be in the purpose of improve the housing problem, but and it's not permitted investor in the cooperatives. The financing mechanisms and tax treatment. Financing is one of the important issues to develop these houses. Capital base, the member contribution equal or calibrate to houses type and size. The members have some savings in the cooperatives, and after that, they join these savings with subsidy from the government or subsidy from the government plus loans from the bank to buy the houses. The main source of financing the property of the housing is bank lending. We have no dedicated natural cooperative funding lines like in Uruguay. That in South America, Uruguay is something different in the context of the South America. And the Ministry of Housing subsidy program awards projects and provide financing for housing cooperatives and houses from the private sector as real estate developers. They are receiving the subsidy from the government. The subsidy from the government is not for the cooperatives. The subsidy from the government is for the families that are buying the houses. Then the cooperative is one of the actors trying to put these houses to be buying for the members with the subsidy of the government plus the savings plus the loan in the case of loans. Not permitted investor members, the tax treatment, the members' surplus receive favorable treatment. All the operation of the cooperatives will have no profit and no profit means non tax for the operation of the cooperatives. Um, the third-party dealings, the cooperative could have some third-party dealings on lands, for example, and in that case is normal taxing, Chilean taxing that depend on the market and the industry. Reserves, surplus cover losses, refund member shares, and allocate remaining balance of per law and by laws. All the surplus, the reserve, are going to reserve in the cooperatives to maintain the operation, to buy the lands and everything, and are not distribute in any time to the members. Only they are receiving the houses and the operation from the houses and the program that they are applying. No housing specific tax. No, we have no special tax. We have all the taxes to buying the materials, to contracting the building contractor. The industry tax we apply in all the regular operation. The oversight and control, the Ministry of Economy, they have a department, cooperative department, and is overseeing and is having a control on all the operation of all the cooperatives in different sectors. The Ministry of Housing is supporting to the beneficiary, to the families, to subsidies programs. The cooperatives, the housing cooperative, we can form federation. We are in a federation of, in association of cooperatives and non-profit building housing, and I am the vice president of this institution. The regulator may demand any type of legal or accounting information to verify the compliance at any time. The audit, each year we select an audit company to review all the statement, the finance statement, and all the operation of the cooperative in a year, and we present all these results in the General Assembly to the members of the cooperatives. The General Meeting appoint external auditor for the following financial year, but the regulator may request additional document at any time. The education funds, we have not a specific education fund for housing. We have some plans in our programs. We are doing cooperative education, we are doing financial education for our members, but it's something that the cooperative is doing as part of the operation, Conavicop. But we have not public financing for doing this education. Housing cooperatives are excluded from some funds that we have for education cooperatives in agriculture, fishing, labor services, and consumer co-ops. And we are working with the government to have some funds to have some education for the membership. In the case of Conavicop, we're running the cooperative for 50 years. We have built 70,000 houses in this period, and all these houses has been transferred in property to the members of the cooperatives. And we are three, the main cooperatives in Chile. Conavicop is the largest. Provicop is the second, and Bimacaucop is the third cooperatives in housing. And we have two kinds of cooperatives in the law in Chile. We have the closed cooperatives that is only for one program, one housing program, and finish when the project finish. And an open cooperatives as Conavicop that is doing several projects during the life of the cooperatives. We have 50 years, and of course, we have make 20 or 50, 20 programs in this moment, Conavicop is building 3,500 houses in 12 programs, and we are in a continuous working as a open cooperatives. The 2026 population is around 20 million persons in Chile. The deficit in Chile is 600,000 houses that we need to build for the families. It's a crisis now in Chile. It's important all the forms and the mechanisms to finance these buildings, build these houses. Cooperatives are part of the solution. Conavicop is working very hard to deliver homes to cooperative members. We are providing 1,000 household families per year. And we own a construction company to build the houses. We follow all the rules about the urban and construction laws, and of course the concern for the community and sustainability development. And we are developing this education for our members. And the final, we have not a specific rule or law for the housing, and it's important to have this opportunity to improve and to have more specific rules for the cooperative housing. We have no financing for cooperatives. The financing is for all the industry of construction buildings, houses, and we are trying to obtain some specific financing for the cooperatives, understanding that we are doing work very close with the government. And the cooperatives department is doing the job, controlling and inspecting that all the cooperatives are following the rules and following the law that we need to accomplish. And the housing, we are facing a crisis in housing, and we are trying to advance in a more important number of housing to reduce the deficit. This is my presentation. Thank you very much for inviting me to this webinar.
Thank you so much, Mauricio. This was an impressive example. There are a couple of questions to answer from chat, but I already wanted to ask also in Blaze's case as well. Those are very impressive results. In countries where you said you don't have dedicated legislation for housing cooperatives, do you have a very short advice as what would be the most important ingredient or workaround, let's say, to start on this path? Because it takes time to scale up. But what do you think a country that doesn't have tradition would need first?
Who was the question for, Andrea?
It was for Mauricio or Blaise that both presented the context where.
Okay. Yes, well, the issue that is not a specific housing law for the cooperatives means that we are in the body of diverse cooperatives, and we have not a specific rules, and in some cases these rules has been improved directly for the cooperatives department in the Ministry of Economy, uh, making with the reality, so with the search of the reality, they are improving and putting in some documents the good practice for the cooperatives, and it's important to follow these rules because we need to take care of the movement, the cooperative movement, to accomplish our compromise with the membership, to give and to permit to access to the houses. And I think this is an important issue that we need to advance in the law, improving these issues. And in the other side, we have some financial limitation because we have not create all these laws specific for the cooperatives, and in special the relation with the government. In the case of Uruguay, is a very important case. I have been several times in Uruguay reviewing this important advance that the cooperatives they have an agreement with the government to finance this construction of the houses through a system where the members are in the auto construction, and in the other case where the member are receiving the houses financing directly from the government, built by the cooperative or some constructor hired by the cooperatives. This, to have a specific body in the law open the possibilities to the financing, the relation with the government, more specific than we have in the most of the countries in South America.
Thank you very much for those insights. And from the chat, the following themes emerged, and this will be an open question for anyone who wants to take the floors from our speakers. There seems to be a lack of understanding of the importance of the non-speculative provision of housing. Does anyone have any comment on that side?
Sorry, Andrea, I didn't understand the question. Where
I think what the participant wanted to highlight is if the importance of the character of being a non-speculative model understood well enough, I assume, by the stakeholders that have a say in saying should we support or not the cooperatives.
Well, I could offer just my own experience, but maybe then we could turn to our friends in Iran who are also requesting the floor, I believe, because we seldom get to hear about the cooperative housing sector from different parts, including Iran. So this could be interesting. But to answer your question, Andrea, if I may offer my own experience, I recently became a member of a cooperative housing unit in Brussels. And as most of the housing cooperatives, I mean, well, not most, but the renters housing cooperative, we will make the payments for the entire place, to purchase the shares of the unit. We will remain renters from ourselves. However, there is a rent component that we will give to the cooperative. Now, what's interesting, or rather not interesting, is that despite my fellow members in this housing cooperative, paying market prices for the unit, a cooperative unit, which should be otherwise relatively more affordable, there is no tax benefit for this rental amount that will go to the co-op, which the member will never see. Sorry. And it's I believe, a gap in the law, or the understanding with the lawmaker, where they don't differentiate a cooperative housing from the speculative housing sector, wherein if I purchase a housing unit for the same amount of money that I'm entering a cooperative with, I will be able to make a profit after 10, 15, 20 years. And speculate on the housing market to make gains. That's not the case with the cooperative, because there is a cap of 3% is what I will be able to gain on top of my contribution, my shares, right? So whereas the members are doing their bit to not speculate, but the law is not able to distinguish between cooperatives, cooperative housing, and regular housing units. I think that's more the tendency I see in some parts of Europe, unfortunately. But yeah, over to you, Andrea, and just a reminder on this question from Iran.
Yes, thank you, Santosh. Yes, so I invite them to take the floor, and yeah, if they have any remarks or questions they would like to share with us, and yeah, as we're approaching the end of the session, to give a last chance to any other comments from the speakers. So yes, please start.
عرض تشکر از کسانی که این وبینار خوب رو برگزار کردن. صحبت‌های خیلی خوب و مهم و ارزشمندی مطرح شد. در کشور ایران خدمت تعاونی‌های مسکن بیش از 4 دهه هستش و یک خدمت طولانی داره. خیلی از این صحبت‌ها و مواردی رو که عزیزان مطرح کردن توی سال‌های گذشته تو کشور ایران رفت رجوع شده. ما در کشور ایران 10,000 بیش از 10,000 تعاونی مسکن داریم و 2,000 شرکت خدمات فنی مهندسی داریم. مجموعاً بیش از 12,000 شرکت تعاونی و شرکت‌های خدمات فنی مهندسی داریم که از 4 دهه گذشته حدود 1,800,000 واحد مسکونی توسط تعاونی‌ها ساخته شده. یعنی سهم تعاونی‌های مسکن در کشور ایران حدود 10% هست. یعنی تعاونی‌های مسکن اینقدر مشارکت کامل جامعی داشتن. تعاونی‌های مسکن و تعاون کردن تو کشور ایران قانون خاص خودش رو داره، تو برنامه‌های توسعه دیده شده. دولت‌ها هم حمایت می‌کنن. یعنی حمایت دولت‌ها تو کشور ایران یکیش تأسیس زمین رایگان هستش که به تعاونی‌های مسکن میدن. تسهیلات بانکی هم برای این موضوع در نظر میگیرن، به ویژه مسکن‌های حمایتی، چون دولت حمایت میکنه از مسکن‌هایی که به صورت گروه ساخت هستش برای گروه‌های مثل کارگری، کارمندی، فرهنگیان این اتفاق میفته. معافیت مالیاتی ما داریم. تعاونی مسکن در ایران معافیت مالیاتی دارن، یعنی واحدهایی که برای اعضا ساخته میشه از مالیات 100% معافیت دارن. در مورد اختلاف بین اعضا که صحبت شد، بله ما در ایران هم مرکز داوری تشکیل دادیم و اختلاف بین اعضا و تعاونی ها به صورت تخصصی بررسی میشه و پرونده ها اونجا رسیدگی میشه. ما مرکز هم داریم که تعاونی های و تمام این مشکلات و چالش ها رو هاشون خوب. ما در اتاق تعاونی ایران ما مهندسی داریم، ما تأمین زمین، تأمین مالی، همه سعی کردیم به تعاونی های زیر مجموعه خودمون بدیم که کمترین داشته باشیم. توضیحاتی که من بخوام خدمت دوستان بگم خیلی کامل هست. انشاءالله توی آینده اگر فرصت یک زمانی رو برای بخش تعاون مسکن ایران نظر بگیرید. چالش هایی که عزیزان ما تو نیجریه، آمریکای جنوبی، آمریکای شمالی مطرح کردن، ما سال گذشته بهش برخوردیم، قانون رو اصلاح کردیم، مستقل داشتیم، رفت و رجوع شده و یه سهمی 10% از تامین مسکن رو تعاونی های مسکن دارن انجام میده. یه اعتماد عمومی هم در کشور ایران به تعاونی مسکن یکی از دلایل توسعه تعاونی ایران به خاطر اینکه این استقبال عمومی وجود داره. ما ارزیابی مرتب هم تعاونی های مسکن رو انجام میدیم. حدود 86 پروژه های ما سر برنامه زمانبندی با اون جزئیات مالی که تعریف کردیم داده شده و اون درصدی که ناموفق بوده تو بخش خیلی کم بوده. به عنوان یک تجربه خوب و ارزشمندی نظر من میشه پالیسی مطرح کرد و با کشورهای شبه اشتراک گذاشت و اون نقطه نظرات دوستان هم گرفت که انشاءالله بتونیم یک شبکه کامل جامعی رو داشته باشیم. من تشکر میکنم از تک تک عزیزان و دوستانی که در
Thank you so much for your intervention. It is indeed encouraging to see that there are good practices out there that can help inspire other countries, other regions. I thought I saw a hand up. Did anyone else had any comments to share before we close? If not, maybe let's take one last question that was shared. Yeah, maybe what short advice has any of the speakers as to how we can maintain and encourage the cooperative movement? Is that the one that has to be there first, or that comes when the legislation is also in place? Yes, Ajibola, please.
All right. Thank you very much. I understand. Oh, can you hear me?
Yes.
Okay. Yeah. I understand our time is fast spent. I want to ask this question. Is there the possibility of international financing for housing cooperatives? Probably, let's say in a country like Iran, they have enough to cover themselves and they could maybe finance a cooperative in Vietnam, or a cooperative in South Africa could finance another housing cooperative in, let's say, Zambia. Or, I mean, just a form of cooperation among cooperatives that is that has financial flow from a part of the world to another part of the world, all in support of housing cooperatives. Is there such possibility?
Well, I think this is a big one, a big question. That's worth noting, and we can try to open the conversation through our channels after this session. But I think there is definitely interest, as always, when it comes to financing, because fortunately it's quite a scarce resource, but so much needed even with everything else that is in place. So I think we have reached our time. So I'm mindful of everyone's dedication to join us today. For some is very early, for some is already very late. So I definitely I'm think we didn't manage to answer all of your questions, but please feel free to reach us. I will drop my email address in the chat, and we would the secretariat. We will definitely be more than happy to organize other sessions, maybe on more definite topics, so that we can go in depth. So yes, we will, as said, we will share the recording, the presentations, and yeah, we will be more than happy to hear from you and get more homework then, because our work is important as long as it helps the cooperative movement. So thank you very much. Hopefully we'll keep in touch and see you around. See you next time. And of course, thanks a lot for the speakers who made who shared their valuable expertise.
Thank you
Thank
very
you.
much. Thank you. Bye, everybody.
Bye. Bye-bye.
All right, bye-bye.
Bye.
Bye-bye. It's a pleasure being with all of you. Bye-bye. Bye-bye.
Thank you. Thank you.
Thank you. Bye-bye.
Bye.
Mojibola.